Hi there, students. In today's lecture, I will discuss about one of the key components of environmental law. And this particular component is very crucial because, why I am saying this because it's not that the other components are not, but this particular area of environmental law is quite significant in comparison to others because most of the issues relating to environment on one side, and when I'm saying environment, I mean environment protection on one side and industrial or any developmental activity or projects on the other side, revolves around this particular component of environmental law, and that is none other than environment impact assessment. Now, when it comes to environment impact assessment, well, the legal scenario that we have in our country is quite similar to that of the uniform procedure that several other countries follow. But there are certain factors which we have to also keep in mind, keeping the developmental objectives of a developing country. And this might not be similar to that of those countries which are already developed or those countries which are very much below that particular line of development. So the thing is that when it comes to the study of environment impact assessment, one has to keep a very balanced approach because it is no doubt a preventive measure, but at the same point of time, it is again a crucial one because most of these developmental projects that we talk about have a very significant role to play in the nation building and nation building and the country in its progress. They have a lot to contribute to our GDP as well. So we should at the same point be also very cautious about making or taking such decisions which shouldn't cause any which should not cause any irreparable damage to the environment as well as human health, because what we have seen in several such instances where certain projects, certain industrial establishments have caused major havoc and mayhem to human health as well as environment. The notion of EIA is based on the preventive the the it's based on the principle of preventive action. Now, it is basically an instrument of preventive environmental management as it provides a very concrete legal framework of an informed decision making for an informed decision making. Sorry, the thing is that why I'm saying informed decision making, because once you come up with a project, you become a project proponent, there are several key factors that you have to take it into consideration. And these factors are primarily responsible for the environment where you are residing, and it also covers the health of these human beings who will be there in the vicinity or in that particular project establishment. So, nothing should affect these two important aspects of the entire ecosystem, be it the environment at large, water quality, air quality, soil quality, underground or groundwater quality, or be it the so called human health. Now, When it comes to AI, well, this particular, you know, instrument of preventive environmental management was not where it emerged, but we think it did. It didn't come from any international legal instrument. It came from a country. It was first introduced by United States of America within its legal framework of National Environmental Policy Act, NEPA, in 1969. And I believe it became law, it came into force subsequently in 70 or 71. And thereafter, several other countries, like Canada, for example, in 73 adopted EIA, and several European nations also came forward in especially the 90s, the mid 90s onwards, like Belgium in 85, Italy, I believe, in 88, Denmark, Germany, even several Spain and all, they came up with their, in a EIA framework subsequently. But the thing is that when it comes to European Union, I'm just mentioning it here, the Council of European Communities also came up with a directive in 1985. If I'm not wrong, it was the June of 1985 when they came up with this directive titled Assessment of Effects of Certain Public and Private Projects on Environment. And this particular directive was primarily focusing on this so called impact assessment. The term they have used was assessment. However, the other countries in the Asian side were also not lagging behind. Well, became much later, but sooner or later we do all realize the significance of environment impact. Even China in 2002 adopted its EIA law, and this was, of course, in the meeting of the Standing Committee of the National People's Congress of China. They came up with this strategy of a sustainable development where they will prevent any kind of adverse impact on the environment by properly implementing all these, of course, plans and projects or construction projects. And this will be in a very coordinated developmental kind of work, which will be to promote the economy, the society, and the environment at large. But when it comes to India, we have a bit different trend. India adopted its EI notification in 1994 for the very first time. Now, how it adopted? Well, it notified through this. It issued a notification, EI notification of 1994, and this notification was, of course, an outcome of the Environment Protection Act, because the central government, which is empowered by the Environment Protection Act, issued this notification on 27th of January 1994. And this element of EIA became a mandatory factor. It became a mandate for all the project proponents. And the thing is that with respect to environmental decision making of a country, which we have discussed in last couple of months in the midst of this national lockdown and COVID related upheavals, we came across certain laws. We came across several major legislations besides Environment Protection Act, like Water Act, Air Act, Coastal Regulation Zones, so on and so forth. But there were also certain other legislations which were not absolutely under the paradigm of environmental law per se, but they were there even before the Environment Protection Act or all these other statutory, the special statutes came into existence. Like, for example, way back in 1853, I don't know if you're aware, we had this legislation called Shore Nuisance Bombay and Colaba Act. I mean, subsequently, we came up with this Lord Macauley's Environment Penal Code in 1860. But prior to that, there was a law on nuisance, shore nuisance, which was applicable in Bombay and Colaba area of in Mumbai, which is presently Mumbai. So Mumbai and Colaba, this Shore Nuisance Bombay and Colaba Act of 1853 was there. I believe when I was discussing about the Wildlife Protection Act, it also referred to the Elephant Preservation Act of 1879. Well, we had a law which was there way back in 1879, and yet in 2020, I just don't understand. We derive certain barbaric amusements by hurting, killing such a pristine animal. And that is what we came across day before yesterday from Kerala, unfortunately. But the thing is that I believe if because since we were asked to abridge our syllabus, because my fourth module was on, if it was on animal welfare legislations. But I believe if time permits, I'll also, upload some of these videos on lecture videos on animal cruelty law, although it is not part of the abridged syllabus now. But I hope I can, have some discussions on that, provided we have that time left. However, the other legislations that was already there in existence since, I mean, prior to independence, like even Indian Easement Act, I believe you have studied Easement Act, right, of 1882. Then you have this Fisheries Act of 1897, even Factories Act of 1897. They were all more or less talking about environment only. Coming from my state, the Bengal Smoke Nuisance Act, which came like subsequently in 1905 and 1912, was also some of the major environmental policies of British India during British India. And one important wildlife legislation I would like to mention here was the Wild Birds and Animal Protection Act of 1912. I guess, if I'm not wrong, I have mentioned it previously. But these were the legislations which were previously there in existence in our country. But none of them were there with respect to it because this concept of EI was not there at all. In fact, it emerged when the world was starting to take a change. I mean, it was taking its leap. We are in this situation of globalization, but prior to that, we had liberalization, privatization. And when we were taking these giant leaps, it was the demand of the hour to come up with such a law, which will in fact keep in consideration all these aspects of proper decision, informed decision making. When it comes to India, the National Council for Environmental Policy and Planning was set up in 1972, the same year when Stockholm Declaration was adopted. This 1972's National Council for Environmental Policy and Planning, commonly known as NCEPP, used to, I believe, not I believe, it is the fact that it was merely a council, National Council for Environmental Policy and Planning. This was set up in 1972. However, it evolved into a ministry much later in 1985, almost a decade. So the ministry that we all know right now, even that also further evolved to Ministry of Environment, Forest and Climate Change. A division was added. So the journey from National Council for Environmental Policy and Planning of 1972 to Ministry of Environment Forest of 1985, and then finally in 2020 when we have Ministry of Environment, Forest and Climate Change, was massive. And in this entire journey, several such special legislations came into existence. Boards were also established, which we have discussed in the course of this environmental law paper. And you will find it quite interesting that way back in 1992, a policy statement was also issued for abating pollution. A national conservation strategy and policy statement on environment and development was also brought up by the Ministry of Environment Forest in 1992. I believe many of you were not even born at that point of time, and I was just a toddler. And I remember when I was a student like you, and when I came across all these, initial things, used to wonder that back then there was not much of fuss about environment, sustainable development. Maybe it was, but it the degree of environmental activism and judicial activism that we have witnessed in last 2 decades is massive. However, these policy statement of for abatement of pollution and even the national conservation strategy and policy statement on environment and development was the starting point. It was in very nascent stage, and there we saw the integration of environment and development, which I believe is the fourth core component of this principle of sustainable development, as was also noted by scholar Philip Sands in his book. Thereafter, in 1993, the Environment Action Program was also formulated. The prime objective of this Environment Action Program was to improve environmental services and to also integrate environmental considerations into development programs. So, the idea of not jeopardizing development or even not jeopardizing environment, like in order to attain development the cost of environment was also not there, which was I mean it was in a very balanced way. The approach was taken from very initial step itself. Now, we also came across several policy documents subsequently, like, for example, the National Environmental Policy 2006. This is also important for the master students who have studied some environmental policies, water policies, forest policies. Now, the thing is that when it comes to National Environment Policy of 2006, it is believed to be the first initiative which was on a strategy formulation for environment protection, and it was very holistic in nature. In fact, it took a very, causative approach where the causal relationship of the degradation of land on one side and and the other side, and developmental aspects. Because in fact, if you refer to the 2006 environmental policy, you will find that it aims to diagnose the causative factors of land degradation with an objective to flag the remedial measures which were required in this direction. It also recognized the importance of the significance of fiscal tariffs and sectoral policies, which of course is required to take a very explicit account of their unintentional as well as intentional impacts on land degradation. So when these things were there, these policy documents also bounced certain solutions. They have offered certain solutions to control these issues, to like to take a very scientific approach. You take a very well informed decision, you demonstrate certain pilot scale kind of a project, then you go ahead with large scale dissemination. You adopt multi stakeholders, partnerships, involve them, you promote other aspects like organic farming, sustainable cropping, agroforestry, so on and so forth. And of course, all of this on basis of an efficient and well coordinated approach. Now, this policy document was just the beginning. Besides all the legislations that we have discussed, be it Wildlife Protection Act, Water Act, Forest Conservation Act, Air Act, Environment Protection Act, Public Liability Insurance Act, even NGT Act, all these things were there. But see, this policy document was in a way very broad in its idea. If even in this particular timeline, when I refer to 2006 National Environmental Policy, I find it very relevant. And when it comes to this idea of environment impact assessment, I feel that there is a connection, and I'm sure I'm not wrong. Now, when it comes to EIA, there are several components of EIA process, which you can see I have mentioned here: screening, scoping, public hearing, EIA report, monitoring impacts, etc., etc. But these components are based on certain models, theoretical models, Basically, there are two types of EI models. One is a statutory model, and another one is administrative model. India has followed administrative model. But what is administrative model and statutory model? Basically, the administrative model is something where an administration exercises its discretion to find out, to figure out whether the impact of that particular project is there. And when it comes to statutory model, it basically makes the assessment of this particular impact compulsory under a legislation, or it may be delegated legislation. India adopted statutory model much later, but initially, as I was saying a while back, it followed administrative model. So till 1992, India was following administrative model because it was up to the administration to decide. It was the discretion of the administration to decide the impact study, to pursue the impact study. However, when Environment Protection Act came and Bhopal gas tragedy happened, things changed. And with the vocation of this particular EI notification of 1992, India switched from administrative model to statutory model. And then thereafter, I wish to correct myself. The first notification came in the year 1994, not 1992. 1994, the preparation started from 92, but final official notification was issued in 1994. So the first EI notification was from 1994. And this particular notification required all the project proponents to submit an EI report, an environment management plan, details of public hearing, and of course, a project report to the impact assessment, which of course should get the clearance from all the agencies. And thereafter, it was further reviewed by a committee of experts in certain cases. Subsequently, several amendments happened. In fact, it was just the beginning. 94, 97 was one, 2006, 2011, 2015. Some of them were sectoral in nature, them in the sense the amendments. In fact, the 1997 amendment was very crucial because public hearing, the component of public hearing, was made compulsory in that particular EIA notification. Now, impact assessment basically is a preventive measure. And there are several, I would rather say stages of EI, and which I have mentioned. It starts from screening, scoping, public consultation or public participation, use like that. And then finally reaching out to a point when you have this EI report. But if you just break them down, these procedure in a much detailed fashion, well, for B.A.L.B course, where I believe I'll stick to the basics, but out of your interest, I insist you look into some active case studies where these EI reports, you can refer to the websites of the ministry, ECs, for example. Even with respect to forest clearances, you will come across several EI. You will also find you have to just Google, because these things, in order to ensure transparency, many of these EI reports are available. If you just Google them and just see what are the entire frame of this EIA. You can also find the minutes of public hearing with pictures, etc., etc. Might appear a bit formal, but if it has been done sincerely without creating any hindrance for the stakeholders to attend, you will find them very relevant and very interesting also. And when you are going to practice in the court of law, trust me, these documents, the EIA report, the public hearing minutes, all these things, if you ever intend to practice in the field of environmental law, you will find these documents will be very relevant to strengthen your case. So the procedure that I was referring here, if you just break it down in a phase-wise fashion, there are more or less 10 phases, and all these phases are relevant because this is the phase these are the phases where you describe the entire process in such a fashion, and you take it forward, and you identify, you evaluate, you manage, you present, you participate, you discuss, you announce, and finally you monitor, and of course you proceed with your project. The thing is that when it comes to the procedure, the description of the project is required, the description of the environment is required, the identification of the environmental impacts is required, evaluation of environmental impacts, the management and the control of the impacts, the presentation of the study, public participation, and finally the judgment by the authorities. They are all relevant. Now, when it comes to the procedural steps, I'm making it very simple for you here, but I insist you refer to the notification. You start with the 1994 notification and thereafter, because for this you don't have to struggle. It's all available on Google. So the first phase is the description of the project. Here, when it comes to the description of the project, the objective is to identify and characterize the proposed project. So here you have to consult all the developers, the planners, the technicians. I mean, I'm not saying you have to consult. What I'm saying is that once you get into that, you will find that these are the project proponents. And the project proponents, they have to consult, they have to just understand the description of that entire project. So whoever are involved in that entire project, they will be consulted. And basically, these are the planners, the developers, the technicians, and they have to prepare. Up lately, because of the technology that we have these days, the descriptions have become very technical, highly technical in nature, giving a very clear idea about it. Like you use all this graphical representation, statistical analysis, even geographical indication systems. These are the things which are pretty much there, and the GIS, the DBMS, all these things are used for describing a particular project. Thereafter, when it comes to the description in this particular phase of the project, uh, what are the process, the products, the materials that you're going to be engaged with, that you have to specify. So there will be inputs and outputs. The input in the sense, the process, the products, the materials, the raw materials that you're going to apply. So that will be associated with certain risks. Then comes the output, like emissions, effluents, all those things will also be there, and how you're going to tackle those problems if you are going to generate huge effluents or emissions. So the thing is that there are several challenges associated with understanding the description of the projects itself, because there are technical factors and there are several scientific uh, uncertainty dangling around at the same point of time. Because the thing is that based on the available scientific tech know-how, you have to judge. And the thing is that you have to describe them in the very first place. Full disclosure. If you don't, then it will be trouble. Now, when it comes to the description of environment, which is the next phase, the prime objective is to identify and characterize the affected environment. And here, the government will chip in, the public servants will chip in, and of course, they will also consult, if so required, certain specialists, because they have to see. And here also, with all those, even spatial mapping, what is spatial mapping, satellite mapping and all, will be referred. See, for example, if this particular project comes, whether it's going to affect the forests or any protected areas nearby. Like, for example, recently it was doing around with the news with respect to the Dibang project, hydro project. And there were several questions associated with tigers being seen there, and the study to be done by the Tiger Conservation Authority, Or even the forest department, they were also engaged in understanding what's the canopy cover of that forest, whether there are certain reserve forests nearby, or whether it is coming under the particular project area. These things are very technical, and for that you do also need technical assistance. So here also, all these graphical, statistical, scientific know-how which is available are used to understand and describe the environment and its impact. I mean, on that particular environment. Here, the government agencies, I mean, they are of course primarily responsible, but the input also comes from other stakeholders, like the people who are residing over there, and who might know that environment for quite a long time. They know the pattern. They have the traditional knowledge also associated with that particular place. They'll also be consulted, and they're mostly the data or the survey that has to be done will be very crucial. Now, the thing is that identification of the effects, which comes in the phase three, is again a big challenge, because here you have to identify the likelihood. So, here the identification of likely interaction between environment and the project is very, very, very crucial. And here, all the stakeholders are involved, should be involved. Specialists should be involved, and if so required, you have to adopt certain conceptual and qualitative models also to understand the likelihood of any kind of interaction between project and environment, whether it's going to have a positive effect or negative effect, no effect at all. That needs to be understood. So this is again another challenge here. It's very easy to say over here with the words, but the thing is that the understanding, the perception is not same all the time. And in order to understand, the you know the, you what in real sense the AI process are done is that they in fact further go ahead with certain cross impact analysis. They make certain checklists. There's a format, checklist formats, and the cross impact analysis is there. District administration plays a very crucial role. Yeah, and the private entities or project proponents, they do also hire several other consultancies, agencies, like consultants and all, to go ahead and pursue certain surveys and prepare a particular cross impact of analysis report if so required. And the thing is that these things are required for understanding any potential impact in the environment because of that project. So it depends upon a very wider coverage of area. It's based on several criteria, and basically it's a qualitative judgment based on quantitative understanding. Thereafter comes the estimation, the estimation of magnitude, the characteristics of the impacts, and this is where the evaluation of effects are understood. Here, the specialists or the stakeholders have to play a very significant role to understand the estimate magnitude and characteristics of that impact. Once you understand that there is an impact, there is an effect, you have to also understand and evaluate that impact or evaluate that effect, whether it can be bearable, whether it's not gonna be, whether it will have a very reverse impact. And this has to be done on the basis of an environmental simulation model. And this is usually a job of those technical consultants and experts, and active participation of all the stakeholders, led by the government on one side, the project proponents alongside, and not to mention the other stakeholders. And this evaluation of effects are basically done in several phase manner. It will be based on scientific literature, expert information. And when I'm saying expert, it doesn't mean any professor or scientists. It can also be an expert of a traditional knowledge, a knowledge bearer from a particular community who knows that environment very closely. So, and other expert information or analysis tools are also applied. Like, for example, if you're going to come up with a damp in a particular area, you do also have to take into consideration how far that area is disaster prone. What was the seismic activity of that particular area of last 1 decade or so? How many earthquakes or landslides they have encountered? So basically, based on that, you come up with a very descriptive and classified ranking of impacts. This will all help the EI, the decision makers to come up with certain measures. And there are very subjective judgments also at the same point of time. It's quite technical in a way, like Delphi method, for example, is one such. Now the next phase is the management and control of environmental effects. When it comes to management and control of the environmental effects, you have to refer to, I mean, the decision makers and the project proponents and all. They have to apply their mind to understand the component of mitigation, the component of compensation, or any displacement which might happen because of that, other monitoring measures. So this is somewhere you will find the developer, the state entity, other specialists. They have to work in tandem. And this management and control of environmental effects is based on a very crystal clear monitoring plan and mitigation measures. So until and unless that is there, it's quite difficult to have it. Then finally, you have in phase 6 the presentation of the study, which involves the report preparation. So based on all these things, you have to prepare a report. This report will be open for public consumption in the next step, where you will have a very unclear understanding of any risk which is associated with that particular project. So that risk communication is open now based on this particular understanding or scientific finding, proper survey which we have done in the previous phases. And once this is presented, all those things which we have done from phase 1 to phase 5 will be presented in a very formal fashion. It will be, because it's a formal regulatory requirement now. And this is how you have to prepare it. And you have to also identify whether there are any vested interests involved, whether there is a proper full disclosure of information of the risk which is associated with that particular project that is going to come up there. And this thing will be presented in front of the people in form of public hearings, also known as public participation. Now when it comes to public participation, you'll find that somewhere you will come across the term public consultation. Somewhere it's used as public participation. Public participation is just not merely a process which is mandated by law. Public participation means actual participation, where they speak their mind, of course, rational and prudent mind, where they were not suppressed, where they were not diverted, where they were not stopped, where they were not coerced to say yes or no. Here, the negotiation with the public, several interest groups, other stakeholders are undertaken. Usually, the district administration once again takes the charge, which kind of moderate the entire process. But all the actors who are involved are engaged in this particular stage of public participation. And public participation means the outcome will be opinions, comments, position statements. So they should speak their mind, rational mind, based on the understanding that they have. And it should be further communicated. If there are any conflicting objectives, if there are any plural rationalities, they will all be open now. Because the public objective of public participation is to identify those things, even the hidden agenda of certain groups, interest groups with vested interests. So, based on that, the next phase, so called the phase 8, comes, that is the formal decision making. And this decision making is basically on the basis of the government regulations, and this decision making is further communicated and thereafter it will be implemented. And all these formal decisions and communications are again not subject to any political trade offs, but they are challenges where they are issues relating to these political trade offs, also legal issues, which doesn't insulate it, which doesn't insulate the formal decision making, because these are something which we face in this entire AI process. So, based on that, the decision is announced, and after the decision, monitoring, if so required, is also there. So, the post decision monitoring, if the project is granted consent, will be followed. So, in this particular lecture of today, I just discussed about the phase wise breakdown of the EI procedure. And I'll take one more lecture on EI notification where I'll look into the clauses, the authorities which are established under the EI notification, be it the appraisal committee, be it the state environment impact assessment authority, and even the pollution control board, whether they have any roles to play. In the subsequent lecture on AI, I'll discuss about it before I wind up with this particular environmental law course. Until then, take care of yourself, stay home, stay safe. Thank you very much.